On this episode of the Workers Podcast, we'll take a look at the Workmen's Compensation Act. Now, under what circumstances is the employer liable for injury? And what are the procedures for processing a claim? We'll take a look at these and other questions on this episode. So we're happy to have as our guest today, Mr. Dalma McCoy. He is an insurance professional and he's also experienced with the Workmen's Compensation Act. He's also a member of the Tribunal of the Industrial Court and a certified court mediator. Mr. Dalma McCoy, welcome to our podcast, and I'm so happy to have you.
Thank you. Thank you very much, Mr. Edgehill. You're someone that I respect very deeply for what you're doing, and especially in this circumstance because you have a wealth of knowledge. And I expect from hereafter, the listening audience, viewing audience will be seeing much more of us collaborating on many efforts and eventualities. So look forward to audience. We're having something coming special. It will be a bombshell.
Absolutely, and I'm looking forward to it as well.
Right.
So let's jump right into this Workmen's Compensation Act. Now, obviously, the Workmen's Compensation, of course, will be applied or will kick in, for want of a better word, under very unfortunate circumstances. But before we look at circumstances under which this may be applied, let's talk a bit about the history and the origins of the Workmen's Compensation Act.
The Workmen's Compensation Act, I would say it's very archaic. It came around in the 1950s. And as we know, acts are basically legislation on spirit, the spirit of what was happening in that day. In the 1950s, spirit was in industries, so you have factories. Mm-hmm. So the act was shaped around the archaic things we're talking about, tools that were used, and if certain tools are used, and amputation of a finger. So even today, when you read the act, as I said, the act now number changes so many times. It's now 475, chapter 475.
Wow.
But however, what happened and what we have not been able to do in Antigua and Barbuda is really bring the spirit, the wording in relation to the everyday situation. In that many of the other islands have changed, and what they have is an Employers' Liability Act rather than the Workmen's Compensation. Because Workmen's Compensation is really statute in that after you have worked or have a contract of employment for 3 days, your employer should take out what you call workmen's compensation. Mm-hmm. And statute are normally basic tenements. So under the workmen's compensation, the maximum amount one can get is $150,000.
Okay.
But what has happened now is insurance companies and some countries have upgraded it to what you call employer's liability. And under employer's liability, you can have maximum liability coverage up to $9 million. So I will now try to navigate between workman's compensation and employer's liability. Workman's compensation, you enter a plant. As I said, that is the language they will use, a plant, okay, which constitute anything. Where you work is referred to as a plant, but okay, don't necessarily mean you're going to talk about an electricity plant or whatsoever. A plant is an office, a plant is an industrial institution, yes, plant is a bank, so they refer to them as plant. So once you walk in, so it's during employment and during the course of employment. During employment means that you are on the plant in your office working is during employment. The course of employment is in a situation where you get to the bus station and you get on the bus, which the company provides you to take you to your place of employment, is during the course of employment. Yes. So you're covered during the course of employment. So if you're injured on the bus, that bus basically has two insurances. The bus has insurance covering passengers. And while you are on that bus, your employer insurance kicks in, his workman's compensation kicks in. So you are protected by two insurances.
Okay.
However,
So just stick a pin in it, just for clarity. So all employers are required to take out workmen's
workman's
compensation
compensation, as
policy.
long as you have a contract of employment and you have done 3 days, you have passed 3 days. After 3 days,
Okay.
automatically they should have. If they don't have, they're violating the law.
Okay.
Right, right. So here it is. You get on the bus and you're going to work. You should be there for 8 o'clock. The bus picks you up at 7:30, which you should be there for 8 o'clock. However, if there's an accident on the bus and you're injured on the bus, you can make a workman's compensation claim because you're covered during the course of employment.
Okay.
If you get to your work and you start work and you get injured, you're covered during the course of that employment. While you're on the job, you're covered there for workman's compensation. Now, the protection, as far as the law is concerned, you are working a casual, let me call it a casual accident. You could be trying to take something at a hotel, taking some from the refrigerator, removing a hot pot of water or something off the stove, and the water spot, you get a burn, you're automatically covered
Okay.
by workman's compensation. And it takes a situation, so medical expenses, transportation, loss of wages, those things are basically covered under workman's compensation. You lost a limb is amputated, those things and the calculations go as far as those end is concerned. So here it is that you're working on your job, you're involved in an accident, you are covered under the workman's compensation. So in that case, your employer is liable
Yeah.
for the injury you sustain.
Okay. Quick question. Are there specific injuries or certain injuries that are not covered on the workman's compensation, even though they would have occurred during the course of
Right.
carrying
Right.
out your
So
job?
all accidents that you are involved in while working will be covered under the workman's compensation. The other side of that is that if you are the employee by willful misconduct, so you deliberately
Yeah.
cause an accident to yourself, that will debar your employer from saying, look, you are not covered, and you can have a situation where your claim is not payable.
Okay.
For instance, again, going back to antiquity, you speak about protective gear, a protective helmet, protective boots, gloves. You should have shields all around.
Yeah.
You are working in a restaurant, supermarket. You have a saw, which is referred to as a bandsaw that you push, you cut meat, slicing meat, and it carries a guard. Like, for instance, even on the road, you see these guys using weed whackers. Weed whackers has a guard. Weed whackers have guards. But they deliberately remove the guard for the purpose of a faster movement of cutting.
Yeah.
So here it is. If you employ a number of guys to use weed whacker, they remove the guard. You seeing them remove the guard and knowing that, you warn them, tell them the guard should be always on. And if they remove that, and as a result of removing the guard, they're injured, that can debar them from making a claim, because it's their willful act that has contributed to the injury that they have suffered. However, even if they move the guard and then accidentally an accident caused them to get an injury, and if you can prove that is not the movement of the guard that caused injury, they're still covered under workman's compensation.
Okay.
So strict proof
Yeah.
is on the employer to prove that whether or not he thinks that the employer action was willful, it has got to be proven.
Okay.
Right.
So I'm going to throw another question in here. So, because Antigua Barbuda Workers Union, we're a workers organization. We see all sorts of situations with workers. Take, for example, an employee. He is hired to do a particular task, right? But over the course of time, he's additional tasks are added on, and maybe not formally in writing. Now, let's say someone was employed at a restaurant. They may have been, maybe serving, but along the way they started assisting a little bit in the kitchen, right? But the job description doesn't say anything about kitchen. But suppose they encounter an injury in the kitchen, how would that be handled? So, in other words, is the workman's compensation tied to specific tasks that you may be assigned on your job description in the course of your employment? If you're doing something outside of your job description and you get injured, would you still be covered by workman's compensation? That's the short question.
Yes, you will still be covered. What the Workmen's Company Act say, as long as you're employed by the employer. So you're an employee of an employer and you suffer an injury on the job, you're covered.
Okay.
However, as you're referring to job descriptions,
Yes.
if you're employed on the job to do something specific, and that was your specific job, and you take it upon yourself
Okay.
to divert or deviate from that. Let us say, for instance, you are a standard person working and you go and mess with something to do with electrical work or some kind of work, and you don't have the necessary skills that do it, and you should not, then that can debar you because you should not. It's just like, for instance, you should be wearing a helmet.
Yes.
Now you are going into a skill or going to a skill set where you are not involved with, you should not. So basically, if you do something that you should not be doing,
Correct.
you can debar yourself from making a claim. But the law is so wide that these things, if it can be proved in a court of law that it's not a willful mistake, then you still have leeway to make it. Because the spirit of the law is that as an employee and you're injured on the job, you are basically compensated for the basic medical expenses, transportation, loss of wages. Those things are basically covered. And I'm saying, again, our act is still so antiquated that the benefits are very small.
So now let's shift a bit. Let's talk a bit about what are the procedures for making a claim for workman's compensation.
Okay, what the legislation provides, because as we put it, it's statute. So it fully outlines exactly the procedure it goes through, and the insurance companies have adopted a workman's compensation policy, and they also will have their guidelines of how a claim is presented.
Okay.
Now the situation is, you have a requirement to the labor commissioner, because the labor commissioner controls the employment and everything. So you have a job site, you have accidents, you have near misses, and what the employer is duty bound to do. Accident or near misses should be reported to the labor commissioner, because what happens sometimes, accident or misses later on manifests itself that even the near miss contribute to an accident. I'll explain that a little further to explain. Here it is, you might have slipped on the floor, you went down, you put your hand, you get back up, and all is well. You consider that as a near miss. However, next week you started having aches and pains to the hip. That will be a week on. You now are going to go to the doctor. You go to the doctor and indicate to the doctor, look, I'm having a pain. And I remembered that last week when I was on the job, I slipped. The doctor now listen to you, will have to relate, well, it's a workplace injury rather than just casually you came in ill. And that information on that medical certificate would indicate that you had an accident or near miss accident on your job. However, your employer, if you didn't say that you had that near miss, would not have the information. And also, workman's compensation are what you call a long tail. Long tail meaning that you could have a situation that manifests itself 6 months or a year later. However, they'll be still covered, even though it happened as far as that revenue is concerned.
Yeah.
So what would have happened is that you'd have go back now to your employer and say to your employer, you remembered last week that I told you I have a near miss.
Yeah.
I started feeling some pain, and then when I went to the doctor said, from his experience and from his examination, it seems to be tying back or related to that. So that now would have referred to as a workman's compensation claim. The insurance company always provide what you call a claim form. The claim form will indicate that that matter was reported to a supervisor. They knew of the accident when it happened. However, at that time, the employer did not see the seriousness of it. But however, after a number of weeks or week, they go to the doctor is able to tie it back. So under that, the medical expense to the doctor that you went to and see a week later, even though you did not actually see yourself being injured,
Yeah.
be covered. If you have sick leave, you're unable to work for a period of time, the insurance policy would have covered your loss of wages. So loss of wages for weekly paid person is 75% of their weekly wages after the first 3 days, and for monthly paid workers, 33 and a third percent of their monthly wage for the period of time. So if they're out for a month, they get 33 and a third percent from the insurance company as the compensation. They have physical therapy to undergo, they would have paid that. They would have incurred transportation going back and forth to the hospital or for therapy, that would have been covered under that. And if per se the injury manifests itself into a permanent incapacity, you will be compensated for permanent incapacity. If the injury result in you losing a member, you'll be compensated for the loss of the member. If it manifests itself that, okay, yes, you have lost a portion of a leg and you need a prosthesis, the insurance company would have paid for a prosthesis.
Yeah.
If you fell down, you lost your teeth, they had to replace it with dentures, they would pay for those. So all these things are covered under the workman's compensation policy.
Okay.
You remember very well when I started, I'd indicated that many policies now have moved away or incorporate what you call employer's liability.
Yeah.
The employer's liability has the workman's compensation statute built into it. However, in a situation where the employer is liable, the employer can be sued. And if the employer is sued and it is proven that they're at fault, let us say that out of the suit you put a case together and it's $1 million, then the employer can come up to have to pay $1 million, but the insurance company would pay that because there's a employer's liability policy. So it's better now for you to buy employer's liability policy rather than buying the basic workman's compensation, because the basic workman's compensation only covers up to $150,000. So if you walk into the insurance company and you buy workman's compensation, what will happen is the maximum payout will be $150,000. If you buy employer's liability and you're liable, you have policies going to a maximum of $9 million.
Okay.
And making a little clearer, if you're liable as an employer and you only have a workman's compensation policy which is governed by statute, that the limit is 150,000, and you have proven to be at fault, and the judgment in the court is $1 million, an insurance company will only pay 150,000, and now you will have to pay the difference out of your pocket.
Wow.
So it is important, and as I said, as listeners listen to you, especially in all work-related areas, construction, wherever, it is important And it's appropriate for you to, when you walk into an insurance company, don't go and just ask for a workman's compensation policy.
Yeah.
Indicate to them that you want an employer's liability policy. Because the employer's liability covers the basic workman's comp.
Yeah.
Because as I said to you before, you have a contract of employment. After 3 days of working, the company
Sorry. Yeah.
should, by law, take out workman's compensation,
Yeah.
not employer's liability.
Yeah.
They must take out workman compensation.
Yeah.
So you go to court, the court is going to make certain, the law makes certain that minimal provision.
Yeah.
So the act has a minimal provision of 150,000 you pay in that respect. However, if you take out now the employer's liability, which is additional cap or rider onto it, it's based on the same tenement, but as I said, it covers you in the event. So it says employer's liable. Employer is liable for the accident that was incurred by the employee.
Okay, so now you've worked intimately and continue to work intimately in the insurance space in our jurisdiction.
Yes.
What has been the uptake or the migration among employers, if you have been able to observe that, to employers' liability as opposed to just the bare minimum of the workman's compensation?
Yeah.
What are you observing?
Right. From my professional standpoint, I do what you call, I do insurance brokering. So I represent companies, represent clients with their employees. And I would not, I will tell all my clients, they said to me they want workman compensation insurance. I know when they say they want workman compensation, what they're referring to. But then when I go to a company, I ask them for employer's liability. So I know by buying employer's liability. Some companies have a limit. So they will say, I will sell you employer's liability. I don't think you want more than $1 million, $2 million, because in our court still we haven't had many high litigation cases where you get high amounts, people getting 5 million, 10 million on the workman's on the an accident happening on a work site where the employee is liable. So a lot of folks think that $1 million, $500,000 is reasonable. However, the more progressive insurance companies give you 9 million or 8 million one time, 7 million one time. So I tend to let my clients purchase the employer's liability policy rather than the workman's compensation. But however, you have a number of companies around. You walk in and you ask for workman's compensation, and they sell you the workman's compensation. Some will take time to explain to you what it covers, what are the limits. Some do not, and more often they are not told.
Wow.
So you find you walk in, you purchase workman compensation when you could have been buying an employer's liability policy, and something happens. Because by the time you look around, 150,000 is gone.
Exhausted.
In my field, I have come with a number of persons making claims, and claims are running over 2, over 3 years when they catch themselves. Sometimes they go on 500,000. I would not want to name companies, but a lot of the bigger companies have been paying workman's compensation claims, not really reporting the day-to-day payment to the insurance company. So they inform the insurance company that they have a workman's compensation claim. They would have presented the claim form. They would have presented medical certificate. They will have reported 6 certificates. But what happens in the normal run of things is that the company continue pay the expenses, and then when the claimant or the injured person has recovered, then they submit the claim in totality. So you're going to find that probably having a claim and paying after a whole year loss of wages. Let us say, for instance, that the person probably didn't work for a whole year, and you calculate their loss of wages, they will over 2, 3, 400,000. Then the insurance company now writes a check for 150,000 if it meets within the criteria of the policy, and that's it.
Wow.
So the employer would have paid out 300,000, They only got back 150,000.
Wow.
Because that is what will be paid by the insurance company.
Yeah.
So it's always best to really buy the employer's liability because you have more leverage.
So let's jump back to workmen's compensation a bit. And I think, and perhaps you could underscore this point a bit, the importance of reporting injuries on the job, irrespective of how minor you may consider them to be, because in the long run, it could turn out that this is a workman's compensation issue, correct?
This is a very, very, very important question that you're asking or statement that you're making because it continue to happen. And the law provides, as I said before, accidents or near misses.
Yeah.
The reason for that is that you have a near miss, you have an accident, you did not report it, you go home, and then tomorrow or a week later, you go to the doctor, you tell the doctor that, look, I'm feeling some pain, I was working, I slipped. The doctor is going to put occupational injury on the sick certificate. We have Social Security benefits. If you're sick, you go to Social Security and you're paid some element of sick leave. I think it's a 40-60 split.
Yeah.
However, if the doctor has occupational injury, Social Security does not pay for occupational injury.
Okay.
So then next recourse is your place of employment. When you go back to the place, you go to your place of employment and you said, report, give them a sick leave that says occupational injury. Are they going to ask the question? We have no record. You have never indicated anybody that you got an injury on the job or what happened. So now you're going to say, well, here it is. I had a slip. I didn't seem serious or anything of that nature. So I went home, didn't tell anybody. So now what proof are you? Should they believe you? Should they accept it? You could have been at home. You could be playing cricket, football, or you could be doing something casual in the garden and you slip. So you're putting now an employer who says, look, I'm not aware. I don't know of it. No. And also, it goes back around full swing. Your employer know that you had a near miss or slip, never reported to the insurance company, never reported to the labor commissioner. There's no record to substantiate that, look, here it is that you suffered an accident a month ago. And that accident that you have suffered a month ago now has manifested himself into a serious injury. You're working on construction. You have boots on. You walk on a nail pierce your toe. And you just look at it casually. You said, it just barely works. You're diabetic.
Wow.
And next thing, you're lost. You lose a toe. And then you come back to say that, look, 6 months ago, you walked and you just barely made a gash on your toe. And you didn't see any serious. And now you're saying now that as a result of that accident, we never reported it. So you will now find yourself in a problem with it, whether an insurance company is going to accept it as a claim because it was never reported, or your employee is going to accept it as a claim was never reported. So it is very, very important that anyone on a job site, a slip, something drop on their toe, whether it didn't hurt at that time, it's important that you report it to your immediate supervisor. And you also should see that your immediate supervisor reported it to the necessary, whether it's HR or who the next person is. Because sometimes I have known of employees reporting to supervisor and supervisor never reported it. And by extension, they never report the matter to the insurance company. And also, the matter was never reported to the labor commissioner.
So for absolute clarity again, the employee is obligated by law to report accidents and near misses to the labor commissioner.
The reason for, if there's a dispute or anything, you can always check the labor commissioner's record to substantiate that this matter was reported. Right, so that's the reason why it should be reported. And again, For assessment purposes, the labor commissioner will be in a position to collect data and to know and to look at element of safety records, because I don't want to call any company by name, but in recent times we have had some serious accident with a particular company. We have at least 2 or 3 deaths over the last 2 years. We have had deaths in that area, and there must be something serious about the workplace in terms of security measures and procedural methods of how things are done. Because, as I said, in a workplace, you should have a security officer, health and safety, to be specific, officer, and have specific health and safety guidelines, operation, how employees should do things. Right.
Okay.
For instance, in today's situations, you're working in banks, offices, you know, hear a lot about ergonomics. Things are not ergonomically friendly. What level the iPad or the computer should be, what height the chair should be, whether the back should be erect, whether it should be having wheels, all these things. So we need to be looking at the aspect of ergonomics when it comes to workman's compensation. I don't know if you have heard of something you call carpal tunnel syndrome.
No, I'm not familiar
Carpal
with
tunnel
it.
syndrome is long term. What it comes from, if you type a lot, especially when you have the older typewriters. So imagine a person typing. After typing, the tendons tend to get stiff, and ladies tend to have tightness in the wrists or having pain. They have something you call, if you like work in areas like utilities, and you keep using the pliers and gripping, you have something your pliers grip. So the sensation of that. There's some machine like vibrating drill. If you do that every day, after a while, your ear and your body just respond to those. So those, when I was referring to you that workman's compensation, a long tail, just imagine you're doing something for 10 years. It manifests itself maybe in the 15th year. Now, if a person suffer injury as a result of working for 15 years and there's an injury, the workman's compensation claim will pay for the long-term or the permanent injury that they have suffered during the process of working.
But I suppose those are probably the more difficult
Ones.
cases.
For instance, we
navigate
have, I
through.
remember dealing with a matter where a lady was working in a chemical lab, and working over a period, she developed cancer. And they could trace it back to the chemicals that she was using.
Okay.
And she was compensated. She died as a result of that. She didn't die on the job, but she died as a result of that.
That exposure.
So that exposure. So, and that will be covered under workman's compensation.
Okay.
Right.
Okay. So what would you say, as we come to close, are the most important points, salient thoughts that from a worker's point of view, that they should bear in mind when it comes to workman's compensation?
Right. Now, every company that is operating, hiring employees and employees working, after 3 days, they should take out workman's compensation insurance. But as I said, for me, employer's liability is best. Once they take that out and they take the information, policy, inform the labor commissioner that they have workers, they've taken the work compensation, they issue what you call a certificate. That certificate must be placed on the job site or on the plant at a noticeable place that everyone walking in to see that. You as an employee should make certain that that certificate exists, and you as an employee should ask, do you have a workman's compensation policy covering me, or an employer's liability policy covering me? And also extend to ask how it operates, safety guidelines, all these things you should be asking to make certain this is put in place. When a near miss accident or injury occurred to an employee, you, the employee, should make certain that this matter is reported to the Labor Commission. You call, you get on the Labor Commissioner, Find out, look, I had a near miss. I reported it to my employer. Have they reported it yet?
Yes.
The employer, a near miss, an accident happened, that should be reported to the insurer. So the employee should make certain that these things are done. Because at the end of the day, you are the one affected, rather than having to be going and taking the employer to court now to know or to get an understand that this matter was properly reported, so it doesn't debar you from making a claim on your insurance company. Because if these things are not done, your insurance company can honor or dishonor the claim, or it's up to the insurance company to do. So you're saying, as employer, you have a duty. You have a duty of care for yourself to make certain that these things are in place. An insurance policy is in place.
Yeah.
A certificate showing that, yes, I'm covered by, my accidents are reported. My accidents are reported to the insurance company. It's also reported to the labor commissioner, that in the event anything happens, you have a place that you can pick your records to say these are important. So it's very, very important, not just an employer sitting there and expectation, because I know a lot of persons work in an institution and don't even have a clue whether insurance is in place or insurance is covered. And I will tell you, I think it will be fair for me, I don't have pure statistics, but I think we have probably about 30 to 40% of workplaces that are not covered by insurance. They're not covered. However, the situation is, if you don't have insurance, you are your own insurer.
Yeah.
So when they say you don't have insurance, it's not they don't have insurance. You don't have insurance that you pay for, but you have insurance because of the fact that you are totally responsible for any payment that might be derived for accidents or injuries.
Okay.
Right.
Mr. Dalman McCoy, I can't thank you enough for stopping by and sharing your wealth of knowledge and experience as it relates to insurance, the Workmen's Compensation Act, and everything that surrounds that whole sphere. And I'm sure that our audience got tremendous value from this conversation. Thank you again for being a part of the Workers Podcast.
Yeah, Mr. Agil, you know I am always available. And I always remember someone had this adage, is that there's a wealth of knowledge that in the cemetery, and I want to make certain this wealth of knowledge are laid here, that it can be taken on or broadened. So in any audience that I find myself, I always like to say, audience, you have challenges you're going through, speed dial 464-7820. I will give you information. I'm here. You need assistance, come call on me, visit me. I'm always here to help. So please call anytime.
Absolutely. Well, there you have it. Thank you again for being a part of the Workers Podcast. Remember, a new video is uploaded every Friday. We do appreciate the support that we've been getting and the feedback that we've been getting from you, our very valued and loved, much appreciated audience. Thank you again. I'm Anderson Edger.